We're going to be talking about discrimination today. That is the aim of this particular topic. And I'm going to be doing it from the point of view of from civil claims, really. Most of you will know the Equality Act 2010 is the main legislation which deals with this kind of area of law, but it covers employment tribunals and the civil courts. And I'm going to be looking at it firstly from a background to how the law deals with these cases, what discrimination is and how it manifests and that kind of thing. And then the second half is going to be about the practical aspects of it, dealing with complaints and that kind of thing. So it's not going to be a big in-depth talk about discrimination itself. I'll just give you a bit of a background because it's a big subject all on its own. There's just a quote on the slide there, which just from Robert Kennedy, which kind of shows the importance of discrimination, how it affects society. And that has been increasingly so, I think, over the time since the Equality Act came into force. So why does any of this matter anyway? Well, I mean, the county court doesn't produce many statistics that are very easy to, certainly ones that are easy to decipher anyway, but the employment tribunal does. And although I'm going to be dealing with the civil part of it, the statistics from the employment tribunals are very useful in showing what the effects of these kind of cases are. So you can see on the slide there that between 2021 and 22, the awards in different categories are set out there. And the highest award was 228,000, just over, for a race discrimination case. The second highest, I mean, that was by no means an anomaly. The second highest award was 226 almost for a disability discrimination case. And so that's not very far behind it. So there's quite a lot of money at stake in these kind of cases. And especially when you look at the median and average awards, the median award for discrimination for religious belief, for example, is just under 26,000 and just over 28 for sexual orientation discrimination. So there's quite a lot of money at stake in these kind of cases. And when you look at the fact that, depending on which statistics you read or believe, around 22% of British workers report having suffered some discrimination at work, then that's quite a significant pot of cash that is potentially being put towards dealing with these kind of cases. These are employment tribunal statistics only, so of course there's a lot more, and there's cases that don't go to court and some that go through the county court, etc. And staggeringly, the estimated cost to the UK economy of discrimination is somewhere in the region of £127 billion, if you would believe, the bulk of which is accounted for by gender discrimination alone. But the flip side of that is that organisations which take hold of this and are proactive in encouraging diversification rather than doing what a lot of people do, which is just pay lip service to it, find that on average they tend to outperform other organizations, even financially. And the average for that is about 12% that people get as a return. So there's a direct financial return on having a happy and diverse workforce, if you want to kind of distill it down into brass tacks. But of course, the aim is to have happy employees, happy service users, etc. We also find that a lot of these cases are accompanied by things like subject access requests, whistleblowing complaints, and the time and expense involved in these kind of things can be absolutely staggering, certainly compared to the issues that are at stake. They can be hugely disproportionate. So there's a lot of at stake for businesses. And there's just some examples on the slide of past discrimination cases that have either gone to the employment tribunal or the county courts. And some are more obviously discriminatory than others. In the first one, 89-year-old secretary sacked for being unable to use a computer. Poor old Eileen was fired for not having the ability to use a modern computer. But the court found that there was evidence that her training had been inadequate and incomplete, and that her on-the-job training was ad hoc and not directed. So it wasn't really her fault or anything to do with her age at all. It was how her employer had kind of directed and trained her and failed to support her for that. Eileen never got her job back, of course, but she was £200,000 richer. So that obviously quite a serious claim in terms of damages. Second one was against a major bank, male colleagues playing pranks on female colleagues, leaving a witch's hat on a desk, saying things like "not now, Stacey," whenever she spoke in meetings and things like that. Okay, clearly not right and to be encouraged, but some people would say, well, it's office banter and there's worse things happen in our office, etc. But this claimant missed out on bonuses and promotions because she was considered to be to have a poor perception from her peers. So she, her career was directly affected by that, and she received a huge payment for the effect on her career. A police officer denied application for a role in a different police force after passing a hearing test. She had some hearing problems, but she passed her own force's hearing test. And when she applied elsewhere and still passed the hearing test, she was then actually refused the job because they said that her hearing was likely to deteriorate and then she wouldn't be able to carry out the job. But the point is, of course, you can do it now. So you can't discriminate against her now because of that issue, her disability. A court was asked to consider a bipolar worker who was dismissed. The court found that they were right to be suspended to start with, whilst their employer investigated whether they were fit to carry out the job. But they were then signed off as being fit for work by two separate mental health professionals. And the court said it wasn't reasonable to ignore the advice of separate professionals who've been engaged to advise on that issue. A Chinese couple negotiating with car sales rep, and the husband was talking in English to the sales rep, but then conversing in Cantonese with his wife. He was asked to speak in English by the car sales rep, not doing car sales rep reputation any favor. It's because we're in England, to quote. And the court said that was a degrading and humiliating environment and awarded £2,500 compensation each. There are some that are probably either less obvious or one thing to bear in mind with these discrimination cases is that intention is irrelevant. It doesn't matter whether you intended to discriminate or not. Sometimes you can have really good intentions, but in the end, they end up backfiring. So, for example, one police force moved a pregnant officer to a desk job after being informed that she'd become pregnant. And they did so in an effort to keep her safe and her unborn baby safe. So it seems like a good intention in the background, but a medical professional had said that she was fit to continue her frontline role, and that's what she wanted to do. So unless you're actually listening to employees or service users, then sometimes you can end up shooting yourself in the foot even when you've got good intentions. And the last one is just for those of you like a craft ale, Brewdog, you may have heard of Punk IPA. They produced a drink called Pink IPA to raise awareness of the gender pay gap. But unfortunately, they refused to sell it to a man in one of their pubs until he identified as a female. And the judge said that he must have been humiliated by that and was awarded £1,000 for that. So there's some situations that have appeared before the courts in the past to give some context. But what are we dealing with? What exactly is discrimination? I think there's some things that you probably noticed on that list that just feel instinctively discriminatory, and others perhaps are a little bit more surprising. So we're going to just dig in a little bit into what discrimination is and how we deal with it. So discrimination, you can define it in different ways, but basically it is the unjust, prejudicial treatment of different categories of people. Equality Act goes a bit further than that and talks about everyone at work having a right to be treated fairly, regardless of age, race, sex, etc. And the Equality Act covers a range of people and organizations. So it covers employees, for example, those with a contract of employment, but also agency workers and apprentices and people linked in that way. Self-employed people where they have to personally perform the work, constituents in a local authority area, members of the public who are part of who undergo a service or who are recipients of a service. There's certain specified people in the Act I'm not going to go into. There's things like police officers and partners in a business, etc. Job applicants, of course. And one thing to note is that these claims or complaints can be against an organization, an employer, for example, but they can also be against individuals such as an employee. So claims can be brought against both the employer and the employee, which is slightly different than you would normally find in most aspects of civil law. And in terms of who it applies to, rather than who it covers, then there are, again, a wide range of people and organizations. There's service providers, people like the car salesman, for example, people who manage and own premises, public bodies we know have to have equality in mind when conducting their public services. It applies to employers in work situations, but also the self-employed, and then to associations of a certain size, so clubs and organizations, football clubs, rugby clubs, whatever else it may be, of a certain size. And the protected characteristics are there set out on the slide for you to see. What the Equality Act did was consolidate all the previous legislation, but then also expand on it. There used to be the Disability Discrimination Act and Race Discrimination Act, etc. So certain aspects were covered, but not particularly well. And the Equality Act expanded all of that and gave a more or less a single place for all of these kind of cases to be dealt with. And there are various different types of discrimination. The main types of discrimination are direct and indirect, but then the Act goes into various other different kinds of acts which are prohibited, and they can overlap with discrimination. They may not be discriminatory, but at the same time, they quite often go hand in hand with discrimination cases. So I'm going to cover all of those today, as well as another couple of the more peripheral ones. So let's look at direct discrimination first. At its most basic, direct discrimination is treating somebody less favorably because they have a certain characteristic. So this is the one that's kind of usually most obvious. This is not allowing somebody into a shop because they are of a certain ethnicity or have a disability, or whatever else it may be. The things that you really shouldn't see in a modern society, but occasionally do. But the Act actually goes further than that. That is discrimination against somebody who, direct discrimination against somebody who has a protected characteristic, but it also includes discrimination against a characteristic a person doesn't actually have. So you can, for example, discriminate against somebody by association, which occurs when a person is treated less favorably because they're linked with or associated with a protected characteristic. So you don't have it yourself, but your friend, your spouse, your partner, whatever else it may be, does have that. And you're treated less favorably as a result of that. So an example may be, for example, sometimes education establishments or clubs or societies or whatever have a policy where if they allow a child to become a member, that any of their siblings are automatically allowed to become members too. So if a child is put forward to join this organization, but they have a brother, say, for example, who has a disability, and the organization knows that they're not going to be able to accommodate that disability for whatever reason that may be, financially or physically or whatever, so they don't allow either of them to join. And that is a discrimination against the person who doesn't have the disability because they are associated with somebody who has. And you can also discriminate by perception, which is where, say, somebody thinks you've got a protected characteristic when in fact you don't. So if you are if somebody thinks, say, for example, that you're gay and treats you less favorably as a result of that, then that's a direct discrimination, even if you aren't in fact gay. And you can in fact go, it can go further than that. You can in fact be discriminated against by somebody who knows you don't have a protected characteristic, but gives you abuse or treats you less favorably as a result of it anyway. So if, say, for example, someone repeatedly gives you abuse for being gay when you're actually not, and they know that you're not, then that can be a direct discrimination too. So it goes pretty wide, the definition of direct discrimination. Indirect discrimination is where there are systems or practices in place which disadvantage people with protected characteristics. So it's where a practice is applied to an organization, it applies to a person who's got a protected characteristic along with others who don't have that protected characteristic. And when that criteria is applied, it puts that person with a protected characteristic at a disadvantage, or would put others who share that that protected characteristic at a disadvantage when compared to people who don't share it. So that can be a lot less obvious and sometimes doesn't kind of come about, or it's not noticed until the breach, really. So one example that's come up in the past is where an organization says everyone has to take their lunch break at a certain time. It seems perfectly reasonable on the face of it, but if you have a diabetic, say, for example, in your workforce who needs to take snacks between meals or to eat smaller meals more often and to have breaks at different points, then the requirement to only have the lunch break at that time may directly affect them when compared to other people, and may be an indirect discrimination. It doesn't matter whether nobody else has diabetes and it only affects this one person. If it would discriminate against other people in the organization, if they had it, then that is still an indirect discrimination. There is a defense where you can show that the system used was a proportionate means of achieving a legitimate aim. So that's usually in situations where it's really unavoidable because of the actual nature of the work or whatever, or the service or whatever else that is being done. There's really no way around it at all. And there are other special types of discrimination. I'm not going to go into them in any great detail, but they apply to certain characteristics in certain situations. So transsexuals, for example, are protected from less favorable treatment if they go absent from work due to proposing to undergo, or because they have undergone a part of the transformation process. If their absence is treated any less favorably than an ordinary sickness, if it's an unauthorized absence, say, for example, you're going to treat it the same as you would with a sickness or injury. Pregnant women also have additional protection, and the protection here is against unfavorable treatment. So it's slightly different here. This is not less favorable treatment. So there's no comparator here. You don't have to compare to somebody else's treatment. This is just unfavorable treatment, full stop. So some examples are given, and one of them is breastfeeding, for example. If you're treated unfavorably because of that, then that is an additional protection to pregnant people in that situation, or those who have recently given birth. And in true English law fashion, it's very prescriptive. It's within 26 weeks of the day that you give birth. And then you can also discriminate by unfavorable treatment of a person due to something arising in consequence of someone's disability. Obviously, this is unique to disability as a protected characteristic. So that could be where somebody, say, needs to take regular rest breaks, say where somebody needs to have treatment, say they've got cancer or something like that, and they need to go and have regular treatment. If you record those absences as unauthorized absences and it counts as part of the disciplinary process and prevents them from being promoted, etc., then it could, under some circumstances, be considered discriminatory, because it's in that situation the reason that they have been treated in a particular way is because of absence, not because of the actual disability. And in that respect, a lot of employers or organizations think they're just treating people in the same way as they would the rest of the workforce. But it's the something arising out of the disability that is the issue in that particular case. There are defenses to it if you don't know and couldn't reasonably have known about the disability, for example. And again, if there's like a genuine and proportionate need. So if there's no way around it, really, again. So there may be situations where someone's disability may prevent them from doing a certain job, even if reasonable adjustments are made. I said I'd cover victimization and harassment as well. And I will just briefly go over that. Victimization and harassment, both kind of ancillary matters to discrimination, but very much go hand in hand. Victimization, really, nuts and bolts of it, is where you treat somebody, you subject somebody to a detriment because they are doing something which is mentioned under the Equality Act, whatever that may be. And there's a list of them in the Equality Act, and it's things like bringing court proceedings under the Equality Act, giving information or evidence in connection with the proceedings, doing anything for the purposes of or in connection with the Act, or making even an allegation that somebody has contravened the Act. So it's almost a secondary thing. It's once a complaint's been made, or once somebody's dealing with a complaint, it's then treating that person to a detriment, or subjecting them to a detriment because they are involved in those proceedings. So the aim is to protect people, whistleblowers really, or protect anybody who is just trying to assert their rights under the Equality Act. It only applies to individuals. You can only victimize an individual. But the slightly awkward thing for organizations in this is that once a claim or complaint or whatever else it may be has been made, you can't treat that person any differently because of it, which seems fine. But some of these cases arise where somebody is complaining that an ongoing process or whatever else it may be is subjecting them to a detriment or causing them to be treated less favorably. And by continuing to be exposed to it, it's being perpetuated. So some organizations then take that and think, well, we need to take that person out of that situation, and otherwise it's just going to keep on causing them this problem. So they say, right, you can't go in there, you can't do this, or we'll take you away from here, or whatever else it may be. But if that then subjects them to a detriment because they can't access a service, for example, then they may also now be being victimized on top of what their original complaint was. And that can be quite a difficult circumstance to navigate, really, for employers and organizations. Harassment is usually pretty easy to define. It's unwanted conduct related to a protected characteristic. It has to be related to a protected characteristic, of course, which has the purpose of violating someone's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. Harassment actually doesn't cover, or it's not included in all of the protected characteristics, but although it's not, there are kind of separate harassment provisions for certain protected characteristics. So there's a separate one for unwanted conduct of a sexual nature, which has got the same effects on the slide, the intimidating, hostile, etc. Environment. There's also separate section for gender reassignment or sex, which again has those effects, but also which results in that person being treated less favorably by A because of their rejection or submission of the conduct. So where somebody, for example, is denied promotion for not being a kind of team player because they're not engaging in office banter, but that might be considered sexually harassing banter, then in that situation you may have somebody who is being treated less favorably because of their rejection of that behavior. And one thing to bear in mind is that when the court's looking at whether this kind of environment has been created, one of the things they will take into account is the perception of B, the person who's been subject to this environment, this detriment. So this isn't purely an objective test. The court isn't going to take a step back and say, is it reasonable this person felt this way based on ordinary other people, what lawyers traditionally refer to as the ordinary person on the Clapham omnibus. I don't know why that ever came up, but it did, and it's something that's still said today. They will look at the court will look at the individual person's perception. So if that person has a background, they've been abused in the past, they've been in a work or office where they've been subject to this kind of thing, they might be more vulnerable to this kind of behavior. And the court will take that into account when deciding whether they have been harassed or not. And then after that, they'll also then say, was it reasonable for the conduct to have that effect? So some things are just office banter, and for them to have created an intimidating or hostile environment wouldn't objectively be considered very reasonable. But knowing what that person knows subjectively as well, based upon their own experiences. This table on the slide is from ACAS. It's a good handy reference guide. That's why I've included it. I'm not going to refer to it. I'm not going to go through it, I should say, in any great detail. It's just there so you can see that the anomalies are highlighted in yellow and have some asterisks, etc. So you can't harass somebody as a result of marriage or civil partnership or due to pregnancy and maternity, for example. And you can't indirectly discriminate as a result of pregnancy and maternity. Again, I'm not going into any great detail, but there are separate provisions protecting pregnancy in a much stronger way, for example, covering unfavourable treatment rather than less favourable treatment. So that accounts for why there are some kind of gaps there. And you should also be aware that discrimination can be against a single characteristic or a number of unrelated ones. And the final one I want to just briefly touch on for the kind of the background to the legislation and context of reasonable adjustments. This is what a lot of people think of when they think of the Equality Act. These are the cases that made the headlines when it first came out. This is when people thought it was outrageous that they had to, at their own expense, put in ramps and various different things, and the whole world went a little bit mad, and the Daily Mail had loads of things all over the front page, and everyone thought the world was going to fall apart because suddenly they had to take this into account. Obviously, none of that's transpired. And the truth is that in the end, disabled people, and this is obviously specific to disability as a protected characteristic, disabled people encounter a lot of difficulties that are sometimes just not even obvious, that able-bodied people are completely oblivious to. Give a very obvious example that I'd never thought of before. I stopped at traffic lights on the way to a funeral once, and whilst I was sat there, somebody on one of those mobility scooters was on the pavement, trying to get down the pavement, but it was bin collection day, and on that particular road there was a row of terraces with no front gardens, and their bins had been put on the pavement, and this person on the mobility scooter just couldn't use the pavement, so it had to go on the road, busy junction, all that kind of different thing, and that kind of thing just wouldn't have been thought about by a lot of the people putting bins out on the pavement. And then you have to start thinking, well, what was the council's policy on this? Was there a way around it? Was it legitimate, proportionate aim, etc.? Or has nobody addressed their mind to it at all? I think most people know you can't pass the cost of those adjustments onto the disabled person. With some things, that's quite obvious. Nobody's going to be stood outside a library with a tin trying to collect money from people in wheelchairs who arrive at the front door to try and get money to pay for a ramp so they can actually get into the building or not. But some things are a bit less obvious. So we've had situations before, for example, where you've got maybe like a private tutor who provides online or in-person tutoring, and they get a inquiry from somebody who has a disability to ask for tutoring, and that tutor is going to have to do more work, more prep work, or put systems in place to try and accommodate that person's disability. With some justification, you might say, well, if I'm going to do more work, then I'm going to charge my hourly rate, and it'll cost them more. But the Act does say that you can't pass on the costs of making reasonable adjustments to any extent, is what it says, and that's quite a stringent definition. So in some situations, that or a similar situation may be considered to be passing on the cost. The caveat in this is that you've got to have put the disabled person at a substantial disadvantage. So obviously it's got to be more than just minimal. And it's to make reasonable adjustments. So some adjustments just won't be reasonable. They're too prohibitively expensive. They're not possible. putting in lifts in certain buildings isn't possible, for example, just because of the makeup of them and stuff. So there are situations where it won't be possible, and it will be a objective test considered by the court. So that deals, it's a bit of a whistle-stop tour really of the Equality Act and discrimination generally. It may be news to some of you, hopefully not, but it is quite a difficult act to navigate, and they are quite nuanced, these provisions, so it's definitely worth going over them again. But we're going to come to more of the practical aspects of it now and dealing with cases. It goes without saying really nowadays that organizations should have a robust equality and diversity policy, and that should deal with discrimination as well. And staff should be trained on what those policies are and what they mean. And the organizations that do this best get together, staff forums, groups, think tanks, etc., to either help come up with the policies in the first place or to test them and identify areas of weakness. The way that you deal with these in a way that is best for employees and service users, etc., and for the organization itself, is that you don't just see it as a tick box exercise where you have to have a policy. So, you take one from a similar organization and make it your own, and then it's out there for anybody to see. It's to be actively followed and tested and updated and critically appraised as an ongoing process. And there should be a way for people to be able to give feedback about that. People should be able to perhaps anonymously provide information about concerns, either employees within an organization or members of the public. And although a lot of people see that as potentially inviting complaints, certainly groundless complaints, if you have, as an organization over time, given the opportunity for people to raise concerns and no concerns are raised over that time, and then suddenly you get a complaint or something raised, then you can point to that and you can say, look, we've had these policies in place for however long, never had a complaint under it, or we have had two and they were dealt with in this particular way. It shows an active ongoing monitoring of the process, and is useful for the reasons I'll come on to shortly. And it's definitely true that some discrimination claims have genuine force. They may even have a lot of truth in them, some of them, but an awful lot have no basis at all, and start because of a basic failing in systems. So just the stuff you're meant to be normally doing as an organization isn't being done properly. And then one of two things happen. Either the person starts to genuinely feel like it's only them that this is happening to, which makes them feel like discrimination may well be a genuine factor, even though they don't necessarily know as such. Or some people, on the cynical side of things, use it as leverage to force some action in a situation where you wouldn't otherwise be able to. So where you actually use a protected characteristic to say, this is why you're doing this to me. But the only reason they feel usually compelled to be in that situation is because the service or the whatever it is that's being provided hasn't been done properly in the first place, and then their concerns that have been raised about that also haven't been dealt with properly. So it's kind of an act of desperation sometimes, and it can be useful for that reason to use outside consultants. So you can get companies which will draft these policies for you, but will also test and challenge them to make sure that they are being used properly as well. And then when complaints do come about, there is most companies have, and organizations have some kind of complaint handling policy, and there can be a temptation just to dive straight into that once it's received, and that is absolutely fine. That may be the right way to deal with that, but the very nature of discrimination allegations is that somehow somebody is accusing a person or an organization of some kind of flaw or breakdown in systems and procedures or the service, whatever else it may be. And that means that there is a mistrust of the organization immediately. So you're going to be mindful of who it is that is going to be investigating. If, to use an example, a black female makes a complaint that an organization's unconscious bias is causing her a detriment, then if you appoint a white male from the same organization to deal with that, she may not feel particularly comfortable that it's being dealt with seriously. It's a difficult quandary, because that doesn't mean that you can just pander to anybody who has a complaint. Doesn't mean you can draft in people who are of the same ethnicity, for example, or have the same disability, just for the sake of appearances, so that it looks like you're dealing with things properly. What is key in these situations is to trying to achieve neutrality as far as it's possible to do so. So it's saying, look, we accept what you're saying, we're going to look into it, and we're going to deal with it properly and seriously, and we are going to take it seriously, and we're going to come back to you with some proper answers. And dealing with it in that way in the first place, sensitively and thoroughly, can avoid these complaints being escalated and ending up in litigation and things like that. So it can be useful, again, to use an outside agency. There are organizations who will investigate and advise on these things, independent agencies. I sometimes get asked to deal with complaints from clients, and it's not because I'm necessarily from any kind of similar ethnic background or disability background or whatever else it may be. It's just that I'm in a different organization, and taking it out of the organization and using an independent body is deemed to be, or looks certainly to be, a more neutral and independent way of investigating, especially in circumstances where I, as a solicitor, say, for example, I'm subject to rules for the Law Society and the SRA and certain codes of conduct. So there's a certain amount of comfort that comes from knowing that it's got to be dealt with within those kind of confines. But there are other ways of doing it. You can have another department completely separate to the one that's been complained of, which peer reviews that department, although they have no overlap at all. That it can be dealt with that way. So it can still be dealt with in the same organization, but it's just it's just trying as far as it can to achieve some kind of separation. Because if not, you may end up, it just looks like there's some kind of attempt at a cover up, really, in a lot of situations. And data can be a very important aspect of this, again, for a reason I'll come on to in a second. But when a lot of organizations capture certain types of data related to protected characteristics, when things like applications are made, for example, but you should also capture them, if you can and within reason, within the confines of the law, when complaints are made as well. And the more ethnicity data that you capture, the easier it is to kind of track and trace whether anything is actually going wrong, and to deal with claims as well, which I'll come on to in a second. But people are sometimes squeamish about capturing that data, and rightly so. We're in a world of data breaches and what have you, and you can only capture information that is of relevance and keep it for a proportionate reason. But it can certainly help to see and to track where complaints are coming from and how. It's having robust data that's available to hand is certainly going to help you in these kind of cases. When it comes to claims themselves, county courts have jurisdiction to deal with claims relating to contravention of certain parts of the Equality Act, and they are on the slide, parts 3, 4, 6, and 7. So that includes services and public functions. So, like I say, the car salesman or local authorities, etc. People who manage premises and education establishments and associations, so clubs and that kind of thing. There is a limitation period, a different limitation period, which can be extended by the court or by consent. But one thing to note is that it doesn't really start ticking until the end of the conduct. So if the conduct lasted 6 months, then it would only kick in once that's finished. If it's still ongoing, then it hasn't actually, the clock hasn't started ticking at all. The court has the ability to make any tortious remedy that it wants. The Equality Act does say that they have to consider other forms of remedies before damages, but by and large, these kind of cases, something will already have gone wrong, and by that time can't really be put right. And in many, they will be damages cases, and usually are in the county court. Discrimination claims are often said to have a sliding reverse burden of proof, and I've put section 136 of the Equality Act out on the slide so you can see it. But what it's saying in essence is that a person complaining or bringing a claim under this act has got to first establish a prima facie case of discrimination. They've got to show there's at least the beginnings of an argument from which a reasonable court could properly conclude that there may have been a discrimination. But it's a pretty easy burden to overcome. If you look at the first line, if there are facts from which the court could decide, well, facts come from witness evidence, not necessarily from documentary evidence. So if you have somebody who is convinced enough that they've been discriminated against based on the facts of whatever has happened to them, then they can put that to the court. And unless there's something to disprove that, then they may well get home on that alone. And once they've got to that point where they've established that there may be a claim, then the burden of proof shifts. And rather than them having to prove their case on the balance of probabilities, the defendant now is assumed to have breached unless they can disprove the discrimination or prove that there was no discrimination. And that's really quite troubling for defendants. And ironically, it's actually sometimes more troublesome in situations where there has been no discrimination. Because if you're trying to prove there was no discrimination, and as a matter of fact, there was no discrimination, there's often no paper trail for that. There hasn't been any poor conduct. There is no documentation that shows that something's indirectly discriminatory or whatever. So you're trying to prove, inherently there's been no discrimination, but it's just very difficult to actually pinpoint how you can prove that. So say you've got somebody who's from Caribbean descent, for example, and they make a complaint about an issue, and other people have complained about the same issue, and you look at all your data, and you've got this one from some of Caribbean descent, and then you've got some from white families. That in itself suggests that actually this is a problem that's occurring across the board and isn't just related to a particular ethnicity, say. But if this remains, or if the white families, if you want to put it that way, complaints have been dealt with within a couple of months and the other one's ongoing after 6 months, then, and that's still live, then in that situation, suddenly you've got a different dynamic. Why is this particular one ongoing? And that may infer in itself that there is some kind of discrimination going. But the problem is, of course, often there isn't. Maybe it's just the facts of this particular case. Maybe it's more complicated. Maybe the person themselves are perpetuating it and they're a really difficult person to deal with. So in that situation, disproving the discrimination can be very difficult, and you may end up with some kind of evidence against you, even though it's not actually really evidence against you. Hence my comments about taking the data and having these policies to try and prevent it, to deal with complaints early on as quickly and as robustly as possible. We're coming towards the end now, but I want to go just through a couple of examples of cases that that I personally dealt with. Been many over the years, but these are just a couple which show some of the issues. So, for example, in the first one, the claimant was a member of a fishing association. So remember I said before, associations of a certain size, certain number of members fall within the Act. And he basically fell out with the committee and they refused to renew his license to fish. And he was suffering from Parkinson's disease and multiple system atrophy. And he alleged direct discrimination against the association. He also alleged discrimination arising from his disability, from indirect discrimination, and a failure to make reasonable adjustments. And his allegations were because the fishing platforms where people fish from were in a state of disrepair. Some of them had been subject to floodwaters and had broken, etc. And he said that discriminated against him because his access was less favourable compared to an able-bodied person. Failing to keep them in a reasonable state of repair was not a reasonable adjustment to accommodate his disability, and his treatment was less favourable than others. And this is a really good example of a case where the failure to deal with problems at the beginning in complaints has just compounded the entire situation and ended up in litigation. The association, quite understandably, were at the wit's end with this guy. To be honest, he was a bit of a moron. You could tell that. And ironically, he was actually able to access all of these fishing platforms every week in the lead up to his complaint. He actually didn't have any difficulties in doing that. But they fell out. The association bins him off. He loses the pastime that he loves. God knows why he loved it. People who love fishing are quite happy to stand on platforms for hours and hours on end, fishing away with their rods. Not for me, but I don't hold anything against any of you fishermen out there, or fisherwomen. But he lost his major pastime, and he felt that the only way of dealing with that was to make a complaint against them. They reacted badly to that because they just thought it was all his fault in the first place. He doesn't really have a disability anyway. What's he talking about? He can access those platforms whenever he wants. And so the only way was to get back at them by litigation. And he does that by making the complaint. There were then some text messages between them, which were a bit heated. And because he's got this disability and because he's made a complaint about reasonable adjustments and discrimination, those text messages, he said, violated his dignity, which therefore meant that he was also now being harassed, victimized, because of it all. And the problem with that is that all of this is just so difficult to unravel. We've got direct, indirect, harassment, victimization arising from disability, all these different things. And yet the reality is, on the ground, you've got person A and person B just falling out over fishing and a fishing license, when there's a much simpler way of dealing with all of this. And to a certain extent, it was like dealing with kind of naughty schoolboys and trying to get them together to get it all sorted. But it's a very expensive and time-consuming process in the meantime, and people end up at their wit's end and just, aggressively defending or arguing about these things because they feel really that it's unjustified to have these arguments against it. And in this case, it was, and in actual fact, we managed to deal with this one because I managed to find some social media photos of him playing rugby a couple of months before. So although he genuinely had this condition, it wasn't affecting him really. He was in the very early stages, and he was kind of playing on that to get what he wanted. And this is what I mean. It's all of those arguments he said had absolute merit, but as they stood at that particular moment in time, they weren't affecting him in the way that he alleged that they were affecting him. And then also another case involved the parents of an autistic child who was playing as a goalkeeper for a football club. And the way that autism manifests is different for many different people, especially children. And in this particular child, if they felt that they were in a vulnerable or challenged situation, if they felt that the status quo was being challenged, then that led them to kind of feel very panicky about that situation. So, and what happened was this club had an inquiry from another potential goalkeeper who wanted to train with them, and the club manager said, yeah, of course, come along. But this autistic child then felt that their place in the team was potentially being challenged. He also had some other specific difficulties. He was having difficulties taking goal kicks, for example. He couldn't kick him upfield far enough. So because of that, he was had to have help with other people on the team, and other people were taking his goal kicks for him. And his parents thought that also was causing a situation where his confidence was being rattled as a result of it, and he was being subject to a detriment, basically. So he ended up in a situation where where his parents were alleging that he was being discriminated against because he wasn't being allowed, he wasn't having his needs met, basically. They weren't dealing with this team in a way that was consistent with his needs and his disabilities. But when you distill that down, what that ultimately meant was that his parents were effectively saying, well, my child should stay on this team forever. Their position on it shouldn't be challenged, even if there's a better goalkeeper. He should be allowed to take all of these goal kicks, even if actually it means the team will lose as a result. And it was a very tricky situation because all of those things are kind of right, and they do have to, deal with his needs. And they took him on as a player, knowing that he was autistic, and they can't, subject him to a detriment as a result of that. But at the same time, the team has to be able to be competitive, and you have to balance the needs of all the other kids that are on the teams as well. So again, another one that we managed to fend off, but it became a very tricky, sticky situation involving quite expensive litigation. And it's something that perhaps could have been dealt with in a different way earlier on, which would have prevented that from happening or getting that far. So they're just a few things to think about. I've kind of come to the end of this presentation now, and I hope we've covered the kind of subjects that you want. We've got another few minutes yet until the hour is out. So if there are any questions, if anybody wants to ask anything now, then by all means do so.